Well, each state has its own adverse possession statute and associated time frame, now after which it can be claimed. However, there are elements that must be established to successfully do so. Roger McEowen joins us now to review a Wyoming case involving a fence of convenience and the legal principles involved. As always, Roger, thanks for being here. So just give us some basic elements of adverse possession.
Well, good to be with you, Suzanne. Basic elements are, and I think one of the key ones is many state statutes have what's called a hostility requirement. And that means that I know where the boundary is at. You know where the boundary is at. We both know that the existing fence, if there is a fence, that existing fence is not on the boundary. And I'm going to go ahead and possess your property across that boundary, and you don't do anything about it for the statutory time frame. And in Wyoming, it happened to be 10 years. Well, once that's done, you have all those elements. It's open, it's outright, it's what the law calls notorious, and it's hostile against your true claim of right. I can file a quiet title action in the local county court and have title to that disputed area invested in me.
So we're looking at this fence of convenience in Wyoming. So how does that play? I mean, you're saying 10 years? Is that the statute?
Well, in Wyoming it is. In Kansas, it's 15. In other states, it might be 2. It varies all over the board. In other states, it might be 21. But the point is, for you to be able to assert adverse possession and take somebody else's property pursuant to the statute, you can't have permission. And what this fence of convenience was in this case was that the landowners had a situation where their adjacent properties, the border fell in a location where you just couldn't fence it. It went through canyons, would go through heavy timber, brush, water. And so they just decided, well, let's put the fence over here. And once it was there 10 years, the one landowner that it favored asserted, well, now that's my land. The court said, no, it's not. You both agreed to put the fence there. That is just merely a fence of convenience. That's not a boundary fence. You cannot have adverse possession apply in that situation. And we're not talking just a strip of land, 20 feet wide and a half mile long. This was 100 acres. So when you get out west, the dimensions are bigger. But the point is, you can't have adverse possession when you have permission or you have a fence that's just placed there because the parties agreed to do it because it was convenient to build one there.
So I understand. So both parties really have to weigh in on that and make that agreement. So big takeaways for farmers and ranchers. What do they need to know in a situation like this?
Well, if you're ever uncertain about boundary issues, make sure you get it figured out. And often in a rural situation, a survey it doesn't carry the weight of the day in terms of marking a boundary as much as usage does. So if you let usage go for a long enough period of time and where the boundary's at and that usage is against your true ownership right, you better assert that right, or you could have the potential that you would lose that disputed area.
Oh, great stuff. As always, Roger, always appreciate your insight and, of course, your intellect on a lot of these issues. Roger McEowen with the Washburn School of Law. Appreciate him being here.